Welcome to the Archive 360 podcast titled, Is Data Sovereignty a Myth in the Age of the Cloud? Joining me today is Jim McCarthy. Jim is the Chief Compliance Officer and General Counsel for Archive 360. And my name is Bill Tolson. I'm the VP of Compliance and eDiscovery here at Archive 360. In this podcast, we're going to be addressing issues like what is data sovereignty? Why is it important for companies to understand the regulatory risks associated with it? And how can you ensure your company avoids the risk of data sovereignty non-compliance? With the rising popularity of cloud computing and software as a service cloud solutions or SaaS cloud solutions, where electronic data needs to be stored due to regulatory requirements have become a greater focus for chief regulatory officers and general counsels. By being better informed, you can make better solution choices and ensure future issues and costs are minimized. And when we talk about data sovereignty, it really is there, and we're talking about worldwide now, especially around GDPR. Where is data actually originally generated? And, for example, in a country like France, France has regulations and laws that basically says data generated in France must be stored and maintained in France and can't be transferred to the U.S. or another country without various approvals and processes and procedures and things like that. So when we're dealing with these new privacy regulations, especially GDPR and so forth, companies need to be very aware of where that data is being generated and how it's being stored and who has access to it. So that's what we're going to be talking about today. So, Jim, we've talked a lot about data sovereignty in reference to the GDPR and the California law, the CCPA, and the various privacy regulations that they have put out there. And in a lot of cases, they are number one, difficult and complex, and a lot of companies still aren't brought up to speed on them. Actually, I think we've done a couple of webinars on the subject as well. But in this case, especially when we're dealing with the worldwide generation of data and data storage, and I think I touched on it, but Jim, can you expand a little bit on what data sovereignty actually is?
Sure. Good to be joining you today, Bill. Data sovereignty, it's a concept that information that has been converted and now stored in some type of digital form would be subject to the laws of the country in which it's located. That's the simple 10,000-foot view, Bill. When we unpack that, though, it gets a little bit more complicated. So, for one point, data sovereignty law is not a universal law. It's really a law that differs from jurisdiction to jurisdiction. And then the last part of my phrase is subject to the laws in which the data, is located. Well, where is the data located? And that brings up something called data residency. Now, that's different than a data sovereignty issue. And pinning down where data is located, where it lives, is sometimes hard to do. It's really hard to do, let's say, if a company is headquartered in New York and has operations in 5 other continents. A piece of work that you and I did and started in New York, but then had our resources in the EU revise it before it's finalized, and then perhaps that document gets revised in several different locations of our company. And then ultimately we store it on our system. Where does that piece of data live?
Especially if the system that we're talking about is a cloud environment. A lot of people kind of envision the cloud as kind of omnipresent, circling the world, and it just kind of floats around up there. But one of the things that many people are aware of, but some aren't, is that you can stipulate what cloud data center that data be stored in, and that's an absolute requirement when we're talking about data sovereignty. You don't just say, well, pull it up to the cloud and not worry about where that cloud is. There are various cloud providers who only have a data center in 1 or 2 countries, and that in fact possibly could violate the regulation of data sovereignty if there's not a data center in that given country to where the originator of the data can basically stipulate the data needs to be stored in this data center versus others. And then you bring in the idea of access controls. Gee, it might be sitting in a data center sitting in Paris, but if a U.S. worker in Illinois can access it, does that violate the rights of the data subjects in France?
Yep, exactly. Yeah, I don't know if it's common knowledge that the cloud is not some sort of ethereal thing out in the atmosphere, Bill. But these data centers exist on campuses, within mountains. Some are at sea, so they're all over. The ones at sea, in particular, they may not be in the jurisdictional waters of a particular country. What do we do with that? We had a customer not too long ago, Bill, that had 500 laptops of departed employees in a basement somewhere in a jurisdiction in Europe. And they needed to capture and load all of that data so it could be, archived and ready for litigation hold should anything happen. Those laptops came from employees all over the world. So where does that data live? It was, images stored on that particular laptop. So all of these issues make these data sovereignty laws and complying with them a challenge. And there's pretty stiff penalties when you violate one of these, what we call the cross-border transfer laws, that restrict how data of customers, let's say, is transferred across jurisdictions.
Yeah.
So, I think it's, in my mind, more of a myth than a reality. That doesn't stop many jurisdictions from trying to enforce them.
Yeah, and like you say, some of the penalties can be huge, especially when we're dealing with the GDPR and the GDPR data sovereignty laws around that. And now companies, we have CISOs and CIOs and stuff when we're talking to them are now already aware of those issues and are asking all the right questions instead of just assuming that the cloud storage vendor is going to know and going to do what needs to be done. They're not going to do that. And hopefully during the contract processes, the questions are going back and forth. But I think the bottom line is here: don't assume, because nowadays those penalties can put a company out of business overnight, potentially. And that brings up, kind of a question I've been asked a couple of times, Jim, and that is, the idea of data sovereignty and where data lives and data being subject to only being stored in a particular geographic location. A lot of people assume that was driven by the 2018 GDPR regulations, and I don't think that's the case. What's your opinion on that?
So as to the genesis of these data protection laws, I think that GDPR was one of the more recent laws, but certainly not the start of it. I think we can ascribe its the maturation of these data privacy laws with a young law student in Austria. In fact, some of the decisions lately from the EU still bear his name, Max Schrems. He was a young man who was very concerned about his social media information being available in other countries, and he felt that violated his privacy rights. A David and Goliath type battle ensued, and years later, Mr. Schrems won. And that, I think, kick-started these privacy laws and made them more focused in business, and businesses started to take note of them in earnest.
Yeah, I mean, Max Schrems actually has a long history. That originally, several years ago, we had what was referred to as the safe harbor for transferring data back and forth. And in the Schrems 1 case, he won the case, and he brought up exactly what you said, and he got the safe harbor basically invalidated. So because of that, they created the Privacy Shield. So Mr. Schrems took that to court, and just here lately, very recently, got that overturned. The Privacy Shield was invalidated. Now I just read an article this morning, and he is very closely looking at and preparing to go after the standard contractual clauses, tool that has been used, over these years. And we won't get into that very much. You can look that up. But, if the SCCs disappear, what happens? But I remember years ago, 20 years ago, at a big high tech I worked for, even then we had to be very careful about dealing with our divisions in other countries, especially France, for example, or Portugal, or several other companies, because they already had data sovereignty laws that basically said you cannot move data originating in these countries outside the country, period. And in certain cases, you had to ask permission of the actual employee author to get their written permission. It caused a lot of problems. But the whole idea of data sovereignty has been around, obviously, for a long time, and we've all been dealing with it.
I think a few things are fueling this recently, not the least of which, of course, is the ability of companies to share data throughout the world almost immediately. And the other thing, I think, is that different nations have a different expectation of privacy. And, if I poll my college students, Bill, barely any of them are interested in privacy, and they want to share every aspect of their lives with each other. But so to them, invasions of privacy are not nearly as important as perhaps privacy expectations in Europe. So in large part, these different data sovereignty laws recognize that different people have different expectations of privacy. So these things are efforts to stem the tide of this incredibly efficient way of transferring data and having data visible in all parts of the globe immediately over the internet.
Oh yeah. More and more countries are coming out with very strict data residency or data sovereignty laws around privacy and stuff. I know Brazil has a very tough one. India has a very tough one that is going to be passed here very soon. So, the bottom line is companies just need to be aware of it. And because they're storing something in the cloud doesn't get them beyond the data sovereignty requirements, because, data is stored somewhere. There is nothing in the cloud that actually stores things. There are always data centers associated, and where those data centers are physically located is where the data residency of that data happens. And we started off a couple of minutes ago talking about data residency. What's the difference between data residency and data sovereignty? And data residency in my mind is if I'm going to store data, I choose where it goes based off of maybe tax limitations or business requirements, wherever it happens to be. Data sovereignty is more of a legal obligation, right?
It is.
So, Jim, really companies looking for cloud archiving, cloud information management capability should, like we've said, first be aware of the data sovereignty requirements they may have. Again, they might not have data sovereignty requirements. If you're a small to medium-sized company sitting in, Montana or Wyoming, and you only do business in the United States, you might not, be faced with that, with this, unless we get into some of the privacy regulations around PII and stuff like that. But especially for medium or large-sized companies, this is one of the first things, they need to look at, that data sovereignty and data privacy. They need to be asking potential cloud vendors tough questions about where their data is stored, who has access to it, is it encrypted? Who has access to the encryption keys? If a government asks for the data, are they going to turn it over? Those kinds of things. But again, this is one of those topics that a lot of companies haven't been faced with before, that I think many of them are going to run afoul of.
Yeah. Add to the list of questions you need to ask are, what's the geo-redundancy protocol of your cloud service provider? As we all know, in case of a natural disaster in one region, Microsoft, for example, will have geo-redundancy running in several different regions as a fail-safe so as not to lose the data. But is that geo-redundancy tool, which is useful and we see the utility in it, is that tool in and of itself a violation of one of these cross-border transfers? I don't know.
Well, that's a great point. If you tell Microsoft or AWS or somebody like that, based on my disaster recovery requirements or because of regulatory requirements, I want to have all my data sets copied to a separate data center so that it can fail over if need be. When we're talking about data sovereignty, at least you need to be able to say, well, gee, I need to geo-replicate my data, but it still needs to be within the same country so I don't, so I'm not out of compliance of the data sovereignty requirements.
Right, which is more difficult in smaller countries that may not have multiple data centers, right?
Exactly, and that's one of the problems. One of the issues that we've brought up with clients and potential clients. I mean, we currently work within the Microsoft Azure environment, and they have huge numbers of data centers all over the world. So you're more than able to say, based off of these regulatory requirements, the data needs to be stored within these countries' borders. And if you're dealing with a SaaS provider, maybe an email archiving provider that only has a data center in Vancouver, Canada, only has one in the United States, what do people in the EU, for example, do? In reality, if an EU company is looking to contract with a company with only one data center in Vancouver, British Columbia, or something like that, they can't because they immediately break the GDPR data sovereignty rules by storing it in a data center in Canada.
That's absolutely correct. So, like you said at the outset, we need to be asking the correct questions of our data vendors, and this is one of them.
And that's where you rely also on cloud vendor to offer their expertise and to make sure that you are aware of all of the potential issues, involved. I mean, if I'm a SaaS provider, and I don't want to get my client in trouble, and I don't want to get in trouble, if I'm talking to a potentially new client, I'm going to make sure they know this is where the data is going to be stored. There's an issue with that. And maybe you should look at your data sovereignty requirements. So Jim, another question, and this has to do with, we've been talking about regulatory requirements, but actually has to do with litigation too, and we've talked about this in other podcasts. But litigation often, spans country borders, and if companies are storing stuff in the cloud, and that cloud is Japan or in the EU. How does that work with, for example, an e-discovery request? And I know we've talked about this idea of the Microsoft case and where that went and what kind of laws that triggered.
It did. The Microsoft case that started in New York, which dealt with data that was in Ireland at one of its data centers, was a very interesting case because it tested the limits of this concept of data sovereignty and the enforceability. One of the takeaways from that case is the recognition by governments all over the world as to the very long arm of the law, and in particular U.S. law. We bring up the Cloud Act. The Cloud Act is a law enforcement tool that the U.S. can use to get information maintained by companies in the U.S., but not necessarily data that lives in the U.S. It could be from other countries entirely. Again, using our Microsoft example, Microsoft has a PII on people in, let's say, Germany or France. The Cloud Act can be used to gather just that information. And not only one way, Bill. Importantly, the Cloud Act also allows other governments to apply for permission to get information as to U.S. citizens' PII. So this is a very concerning overreach, some would say, that has now resulted in a breakdown of our streams of commerce when we talk about the standard contractual clauses being undermined, and the recent decision, the Schrems II decision. So this is a big concern that other countries have because, like we said earlier, their expectations of privacy are different than perhaps the U.S. expectation of privacy. And the U.S. has a deference for law enforcement that other countries may simply not share. So, Bill, I think the real question is, how can you, as an enterprise, insulate your customers' data so that it's not susceptible to bad actors or government overreach as perceived by another country? How do you do that?
Yeah.
And you're going to hopefully talk to me about a phrase that I'm not so comfortable talking about because I don't understand it. Tell me about homomorphic encryption.
Yeah, no, this is actually one of the bigger topics that we have clients talk to us about. And we're not passing judgment on the Cloud Act or anything else, but we do have especially European-based companies who are very aware of this, and this is tied to the Privacy Shield and standard contractual clauses and all kinds of these things, and the fear that if their data is kept, even in a U.S. company's based cloud data center, that based on the Cloud Act, the U.S. government can demand that U.S. company take the data from that foreign location in their servers and have to turn it over. And a lot of, especially non-U.S. companies, don't want that to happen, both via intelligence agencies or just from an e-discovery request. So sometimes they'll say, well, gee, we want the data kept, in a foreign country's data center. Well, if that data center is owned by a U.S. company, then the Cloud Act could cause problems. So what Jim was asking about, encryption and homomorphic encryption, one of the only ways to really protect against that is for a U.S. company or a data center to offer the ability to do localized encryption, on-premise encryption of all data, and keep those encryption keys on site, so that a government agency, whatever country's government agency, can't go to that data center in whatever company it is, and we've talked about secrecy orders before, going to the company and saying, I need company ABC's data, and you need to turn it over to us. And oh, by the way, you cannot tell them that you turned it over to us. They will never know. And companies obviously are a little nervous about that. So the idea is to actually locally encrypt that data before it's moved into the cloud, keep those encryption keys locally. Therefore, even the cloud solution provider cannot offer that data, can't decrypt that data. So, if that foreign country really does, for whatever reason, need that data, they have to go to the data's owner specifically and say, here's a subpoena, here's a warrant, turn over your data. And that gives the data owner the ability to fight it in court before they turn the data over, instead of it being just turned over blindly and the data owner never knowing that it was turned over. And homomorphic encryption actually gets into that and allows for that fully encrypted data to be moved into the cloud, but also be fully manageable. Because you can imagine an encrypted file is absolutely unreadable in most cases, and that's stored in the cloud. It can't really be managed except maybe based on length of time or something like that. But an archiving system with homomorphic encryption allows them to have a fully encrypted set of data in the cloud and have it be manageable, referenceable, be able to run analytics on it and all that kind of stuff. So the idea is everybody should be looking at the idea of doing on-prem encryption before utilizing any cloud repository. and that takes this whole idea of intrusive e-discovery or government agencies going in and getting access to a company's data without them knowing it.
That's a good point. When you were explaining homomorphic encryption, Bill, I thought of the adage that was, if a tree falls in the wood and nobody hears it, did it really happen? So I guess what you're saying is that if this data is field encrypted or encrypted on-prem before it goes to the cloud, and it is indeed hacked by either a bad actor or sought via a subpoena, you can't read the data.
Yeah,
so
it's useless. Yeah.
In my mind, then that is a terrific preventive step so as to comply with all of these data sovereignty laws. For example, the EU has 28 different data sovereignty laws, and many more throughout the world. So by creating this field encryption or the homomorphic model, in my mind, I can defend all of those data sovereignty laws in one fell swoop.
And that brings up a question I think I've asked you in the past, and I don't think we have an answer for it, but the idea is this: if I'm in France and I fully encrypt a file and keep the encryption keys on-prem, and I store that file in a cloud in the United States, have I violated data sovereignty? Because it's absolutely unusable.
So, without getting too deep into the definition sections in each one of these data sovereignty laws, I think at a minimum, it has to be data that can be viewed. In other words, if you see a evidence of data but don't see the data itself, how could you logically be held to be violating any law itself?
I think that is absolutely true, and I think that's a really interesting topic that I think the GDPR authorities need to address, and somehow I don't think they're going to do it anytime in the near future. But I think your description of the data needs to be viewable to have violated the sovereignty requirement. So what, and if that's the case, what does that open up? I mean, gee, if I fully encrypt my data and then store it, in the United States, are people going to do that? In reality, they don't really need to because there are data centers all over the world. But I could see that question coming up from some clients in the future. So I think we might need to at least have a stance on that sometime here in the future.
I think a CISA would welcome the opportunity of being able to comply with all of the different laws that are out there by simply doing one preventative step.
Yeah.
And I think this homomorphic encryption may just be that prescription.
Yeah.
I mean, in my mind, that truly enables a customer to get end-to-end encryption.
And meet their privacy and sovereignty requirements at the same time.
Yeah.
Yeah. I mean, data sovereignty now, as well as privacy, is really come to the forefront and is a critical issue for many companies doing business, especially those doing business in other countries, or at least purchasing PII from other countries. Especially from the EU and stuff like that. In my mind, it's always a great idea to ask for written opinions from your legal department or your outside legal counsel on your current or planned data handling and storage procedures. I have a new process for storing stuff. Nowadays, it's probably a good idea to get a written opinion from your attorneys before you actually spend money doing that, right?
I would agree. I mean, setting this up in advance, it brings up the other adage is an ounce of prevention is worth a pound of cure, right?
Oh yeah. I mean, I once had a law firm partner tell me, he said, always ask for legal written opinions on this kind of stuff from your legal department or outside legal counsel, because they are your insurance policy, you being the individual. Because if something bad happens down the line and everybody's looking at you because they think you made the mistake, it's always nice to pull out something saying, no. My lawyer said it was fine. So I've always kept that in mind. All right. Well, Jim, that again wraps up this podcast on data sovereignty and information governance and those kinds of topics. Again, if anybody has questions on these topics, please send an email mentioning this podcast to info@archive360.com, and we'll get back to you quickly on it. We are going to continue to be generating new podcasts and keep an eye out for new ones as they appear. But please, if you do have the time, we'd love to hear about what your opinions are of how we're doing the podcast, the content, all of that kind of stuff. So please let us know. And with that, I will close it. And Jim, it's been great as usual. I appreciate the time, and until the next one.
Good speaking with you today, Bill.
Thanks.